Hello, everyone. Welcome to a really special YouTube Talking Feds. I'm with two people, friends who need no introduction, and I won't introduce them, but Elliot Williams and Norm Eisen. And, I and they have been in a flurry of conversations since yesterday's news. I'd like to approach this a little bit differently from those because it strikes me, that was the monumental moment we'd all been waiting for, but now it's really day one of a new era with different rules of the road, especially legal rules. And I think we can try to really give our best insights and education about some of those more. You could call them technical, but they're going to really be pivotal. So, Norm, Elliot, thanks for joining.
Hi.
And
Hello.
And let's just the
Hi,
three
Mary.
amigos do what is it? Yeah, exactly. Dude. Look, let's just launch in legally. Bragg, it seems to me, you has a factual hurdle and a legal one. We'll get to the legal one in a moment, but the whole game has been, well, what's Trump's state of mind? How do you prove guilty intent? And the important point that I realized waking up today is we now funnel this through a legal system with rules of evidence and a lot of protection of defendants' rights, etc. So let's just start there, which in a way might seem easier to us in the world. People can see Trump's guilty intent almost just by, watching him, but that's not how it'll work in a courtroom. So I wonder about your thoughts for both Bragg and Trump when it comes to the pivotal factual issue of state of mind. How are they going to go about proving beyond a reasonable doubt, or Trump injecting a reasonable doubt into the question of whether the payouts and the like were done with guilty intent to evade the law?
Let me say this. All I'll say is this.
Yeah.
If you remember the Grinch at the end of the movie, his heart, although this as the one Gentile on the call, I'm sure you still have seen the Grinch film, but his heart grows 3 sizes at the end. Norm Eisen's heart grew 3 sizes when he knew that the first question, or now the first question is on the state of mind, intent. I'm going to turn it over to my friend Norm Eisen, who the heart just, because I know this is his bread and butter.
He is the holder of the Norm Eisen freestanding chair of guilty intent in the whole U.S. of A.
For viewers should know Norm thinks about this very question a ton. So
incessantly. Well, that is the nicest comparison to the Grinch that I have ever received personally.
Have there been many?
Undoubtedly, in my long legal career, there have been some, even if they're not coming to mind. I think that the intent question is going to require Bragg to go back to the genesis of this hush money scheme as it relates to the 2016 election, which is August 2015, the meeting, Trump, David Pecker, Michael Cohen, and Trump asks Pecker what he can do to help him if there are scandals that seem to be emerging. And Pecker offers and Trump accepts to use the National Enquirer to pay for these scandals and then to kill them.
Let me stop you there. We're gonna keep going on this, but Pecker offers and Trump accepts. Sounds like conspiracy to me. Do you see that as being the framing device of the indictment? Either of you?
Well, I've started talking, so I'll I'll let Elliot
Sure.
answer on conspiracy.
Well, I mean, look, that is the essence of a conspiracy. It's,
Right.
do you wish to join in this agreement with me? Yes, I do. Let's take a step toward it. And that is the formation of a conspiracy. And it could be. Now, something
And
we
Pecker,
have,
of course, the last witness in the grand jury. Yeah.
and let's add another point on top of that, something we've talked about, Norm and I talked about on air the other day, which is this idea of Pecker can potentially be used as direct evidence of any number of the crimes, of potential crimes. Again, we're still learning, and
Yep.
we'll learn more next Tuesday when this all comes out. Direct evidence, but also perhaps pattern evidence, which can come into
Yes.
court under certain circumstances, that a defendant engaged in the same conduct over an extended period of time, even if those other instances are not charged in an indictment. So it was interesting seeing David Pecker come and show up at the end as a witness, because you could sort of try to unpack why he was there, but there's a few different reasons for his testimony, possibly.
Yeah. Back to you, Norm. Okay.
All of us have spent a lot of time in courtrooms, and one of in terms of Pecker as the next to final witness, because we know there was some other mystery final witness who showed up on Thursday before the indictment was voted by the grand jury. When you try a case, you want to have that sense of closure for the jury. So to go back to the beginning of the conspiracy, and to have Pecker as the penultimate witness to kind of tie things up in a bow, I think is wise, because really that gives you the intent that you need under New York law. What you have to have for this books and records violation of Trump repeatedly booking hush money as legal fee repayment to Cohen, you need to have the intent to defraud. And here it was the intent to benefit the campaign without accepting unlawfully large and corporate contributions, or impermissibly large contributions from an individual. And so I think that's where you start. You've got to show, and there's going to be a fight about this intent issue, including do you have to show pecuniary loss, that there was an intent to rip somebody off financially. I don't think that's the law in New York. I think that Trump's intent was made clear. And then the last thing I'll say on this, this is not going to be a case just about Michael Cohen's testimony. Michael has been rock solid with me since I interviewed him at the beginning of the impeachment. He hasn't wavered on this hush money stuff. But there's a ton of corroboration for Cohen, and Pecker's testimony about this meeting in which the plan, the scheme, the conspiracy was formed is going to be very, very important. And there's documents and texts and emails and signed checks and a lot of other corroboration. So I think we'll see, we'll get the next clue when we get the indictment. But I think there's good, strong, multi-dimensional intent evidence.
What do you think, Al? I mean, Pecker not simply corroborate. I mean, to the extent we've been thinking about it as the payout of Stormy Daniels and the camouflage of those payments as legal fees to Cohen. Pecker has a sort of a dual role. He not only substantiates that, but he lengthens the whole thing. He makes it back to 15 and also forward, if you're looking at it as a scheme and conspiracy, at least to the point where Trump in the Oval Office signs these checks over to Cohen. And that also serves the kind of subsidiary purpose in the real world, but in the courtroom, of rebutting the suggestion that it's all kind of penny ante, and what some Republicans have come out of the box, not having seen a word of the indictment, to call an accounting error of a case. Yeah, sorry.
Well, a couple things. Penny ante is still, it may be small, but it's still a crime, and misdemeanors are prosecuted across our country and can frankly be quite serious depending on the misdemeanor. So the idea of it's not serious enough, I've never found to be particularly compelling, and have chosen to focus far more on, what is the strength of the evidence as presented, be it for this misdemeanor or if elevated to a felony or anything else that we haven't seen. Now, to the Michael Cohen point, and even agreeing and stipulating to the fact that his narrative with respect to the facts of this, what we believe to be the facts of this matter, have never really wavered. He's been pretty clear in his testimony before Congress and so on regarding the payments and Stormy Daniels and so on. I do believe in my bones, and I know Norm and I have disagreed on this a little bit, that it's still a witness with significant credibility issues for a couple of reasons. And the broad point is that one can still secure a conviction. Prosecutors can still secure a conviction with problematic witnesses. We've all, I know, Harry, you as a prosecutor formerly, have had narcotics cases before. And if you've ever had a drug case, you're dealing with people who are either addicted to drugs or have convictions for selling crack or crystal meth or whatever. And you got to get that past a jury. You can still get a conviction. It's just something you have to confront. In the form of Michael Cohen, you have two issues. Number one, I believe the number is 9 felony convictions in federal court, including for dishonesty issues, right? And also a demonstrated sort of beef with the what's likely to be the defendant here. What we know is the defendant, Donald Trump, including we are having this conversation now on Friday the 31st. Last night, the evening of the 30th, he gets on CNN and says, "See you Tuesday, buddy," and sort of wags his finger, which, frankly, if I were a defense attorney, I would try to get into court on that day.
Yeah, and if you're the prosecutor, you're going,
if you're the prosecutor, you're pulling your hair out. I don't know what it's like to have hair, but if you did, if you're the defense attorney, you want to get that in, saying that this witness has an axe to grind with the defendant. Now, none of that's not to say that, and again, I will agree to, number one, there's plenty of corroboration of the statements. Number two, you would not.
Well, and what? Let's surface that.
Like you said, you got the checks, you got other witnesses and so on. But the
you got Hope Hicks, right? You got some real.
But I just have been burned enough times by juries that see a witness and say, well, if that guy was lying back then, is he telling the truth today? Or can we trust this guy? I don't know. And it's just enough to plant that seed. That's my casus belli, as it were. Maybe that's not the right Latin term, but on Michael Cohen generally.
Let me. I sort of want to split the difference. I agree with Norm to the extent his brief has been, since in Congress, Cohen kind of changed his tune. He's sung very consistently. Yes. But we have to see this now from the standpoint of a nasty, very well prepared defense attorney. And the points Elliot made, I think, are correct. But I think, if Norm's thinking, look, you can show he's been consistent in this story, that helps a lot. But there are, and we all are friends with Michael, but just have to lay out there. They're going to try to make hay of a couple additional lies. So I have found that juries will give a pass, arguably, to the big lie that's now been changed. But there's some suggestion that they'll be all over him for disclaiming any interest in being chief of staff when it looks like maybe he wanted to. Some maybe possible prevarication on Russia. So they're going to come after him, of course, with all they have. Actually, here's a good kind of trial lawyer's question you guys never expected. And I want to say to everyone, it's really helpful. We have a diversity of experience here, of different kinds of lawyers on both sides, civil and criminal. When do you put Cohen on? Is he one of your first 2 witnesses? Last witness, and that we'll get to the defense case in a moment, but presuming that their number one goal is to just discredit him, when do you want the jury to hear that dramatic battle?
As a lifelong defense lawyer, I would put him in the middle. So you build up some of the story before he goes on, and you have additional corroboration afterwards. Not just witnesses to rehabilitate him. So you find a way, and obviously we are all fond of Michael. We've gotten to know him. He was I think the first witness I talked to in the impeachment. It's no knock on Michael to say as much of the case as can be presented on an independent basis, like by having Pecker talk about the formation of the conspiracy if they end up charging it as a conspiracy. They very commonly will charge the books and records charges are their mail and wire fraud in the Manhattan DA's office, and DA's office is generally in New York. So they could do this charge just as, every single false entry is another count. Be that as it may, you want to use Michael, sandwich him in between other witnesses.
This touches on a really important point that the non-prosecutor or defense attorney public may not understand, which is that putting on a trial is a lot more art than science. And there are decisions that folks on both sides of a case need to make, and rational choices of, well, what order do I structure my witnesses in? How do I think about my opening statement, and what are the points I hit first versus second versus save until the closing at the end or whatever? But this kind of thing is, well, how do you do? I think you got your opening statement, you lay out the beautiful hour-long speech that lays out all your proof. I think you start with the boring stuff, the checks, the guy with the green shade, the green eye shade, the little nerdy accountant guy, to walk through. These are the checks that we look at, all these bad signatures. Oh my, is that Donald Trump's signature on 11 checks? My goodness. You build the case a little bit, and then you go to Michael Cohen, who sort of fills in the blanks a little bit. And also you raise on his if you're the prosecutor, on his direct examination, you raise those convictions and you say, Mr. Cohen, before we proceed, you have a criminal history, don't you? You get it out there on your own. Don't let the defense tease it out. Then go through your questioning of him, and then let the defense beat him up a little bit, and then come back and sort of rehabilitate him.
So that's one possibility, and this really is, we're getting right to the trial lawyers' art, and they'll decide. But I think the alternative, and it's I think what Norm was maybe getting at, is you do those things, but then you do Pecker, or you do something to sort of set things up. Then you have Cohen, and then assuming he's going to get beat up, you have, maybe Hope Hicks is your last witness. And I'll just say briefly for people who don't know it, she figures in first. She's got, as I've heard in another case, a face like an affidavit. But she can she's in on a phone call when Stormy first surfaces, and one just after Cohen pays. I want to go to how Trump approaches this, but you made a really good point. Okay, go for it. Yeah, you got to have the Norm Hope story. Yeah,
I was.
You what?
I was the designate.
Double date? No.
When we took her deposition in impeachment, and she was truthful, credible. She did not, play games to help or hinder Trump. She is a very good witness, and I think a lot of these witnesses will surprise you. I've known Kellyanne Conway for a long time. I think she'll get in there and tell the truth. These witnesses are not going to risk them perjuring themselves to help Donald Trump. So, that's part of the reason Bragg took some time to bring this case. He wanted to figure out these kinds of questions. You don't want to figure this out after you indict. You want to know what your strategy is to deal with the attack that's coming on Michael. So
that's a really important point, by the way.
Closer.
That I think he had the grand jury. He could have taken the vote whenever, but there's things you can do in a grand jury that you can't do once it's dissolved, and he wanted to make sure those T's were crossed and I's dotted. But you guys both, well, I think, Elliot, you raised a point about all these counts. I think, we should wait to see the indictment and what exactly it says, but I think it's pretty clear that 34 counts, if the Times is right, means separate counts as to each of these checks, and maybe multiple ones. So my question to you is, does this feel overcharged?
Oh, I can't and won't really answer that, Harry. It's hard to say what is in the
Yeah.
34. Was it 34 different instances of conduct? Is it 34
Yeah.
things that we've
I
never
think it's
heard about?
33.
33.
Okay. Well, go ahead.
Whatever it could be. It's just hard to say. But your point's well taken that someone who
Yeah.
writes, say, 11 checks could potentially have had multiple crimes with respect to each check. Each time it was, sort of noted in records a certain way, or
Right.
but
That's the
again,
government for you.
but again, it's for the broader point is it is unsurprising that 33 counts in a criminal indictment don't refer to 33 different crimes or 33 different instances of misconduct. They might be, some might be misdemeanors, some might be felonies. Who knows how they do it?
Well, we know we're dealing with 11 checks here.
Yeah.
I think 6 of which Trump signed. The others signed by Weisselberg and Don Jr. So that by itself, you could have 11. Each of those is a false financial record. So that you've got 11 to start. That's before you get into all the books and the records. But they could slice and they also may be slicing and dicing those 34. Elliot and I were part of a conversation. Well, could it be each check and then you have 2? Oh, Harry, you were part of that conversation too. Each check and then you have 2 bookkeeping entries. That would get you times 11 to 33 and then a conspiracy charge to wrap it in a bow. But that may not be accurate. We really do have to see the indictment.
Well, yes and no. Look, for the legal theory we do, but there's no other way we get into the 3 dozens than something like that. And the question will be whether
you're operating under the assumption that this hush money scheme is the sole matter for which the former president may have been charged, and there may false statements.
Good point, but I'm not.
Right.
I'm not. I'm just saying
okay.
You can't get that high without this. Look, the alternative is for a jury and the nation to charge fewer counts or to avoid the kind of the prosecutor's credo. I know it's different for the different rules in the justice system is not to overpromise. Yeah. So will there be some feeling come Tuesday? 34 counts sounded like the crime of the century, and you're really let's turn to Trump because we have again rules are now different. He has suggested his defense. Well, first, his defense is first, he never had sex with that woman, which is perfectly irrelevant, I think, for the charges, but might matter. But second, we've had these suggestions, including from his counsel, that he was just doing it to spare the feelings of Melania. Let's say that's your theory. And, Elliot, you're really right that the good trial lawyer is going to spend all the time up front knowing her or his theory of the case. I was taught, and whenever I had the time to do it, it was a great technique to write your closing argument first and then, go backwards. But now you're Trump. You want to inject reasonable doubt. You want to make them think maybe it's just to shield Melania. How do you do it?
Well, it very well might have been just to shield Melania. But how you show a jury is that he was aware of. So imagine if it's campaign finance law. And as a campaign finance violation, you would have to demonstrate to the jury that he very well may have found this embarrassing and wished to conceal it from his wife.
But who's going to testify to that?
I don't know. Find a witness.
That's the question. I'm going down in the
a specific
down and dirty of the trial lawyers. How are you going to prove it? You're
Perhaps this is all speculation now, but you get someone close in his orbit. Imagine he says to Michael Cohen, "God, my wife can't find out about this." Right, and that comes out at trial. It's
objection, hearsay,
admission by a party opponent.
Not as offered by the party opponent. Not as offered by the party opponent. No, that's really what I'm saying.
Yeah, I
was on O'Donnell, and he said, "Doesn't Trump have to testify?" And my answer was, he has to testify, and he can't testify. So that I'm sorry, I didn't mean it. I meant it more in the nitty gritty of the trial lawyer's art. He can, Let's start there. Any chance in hell, if this goes to trial, that Donald Trump testifies as you see it? Norm or Elliot?
No,
right?
Donald Trump has no. Donald Trump, for the same reason he took the Fifth
Yeah.
Amendment 400 times in his civil deposition with the AG Tish James's office. I just think Donald Trump has too difficult of a time between truth and falsity. He's too volatile. He's on the record lying about this. You talk about Michael Cohen's problems. I think you have to. I think you have to build a defense without Trump. You never know how defense lawyers will see things. I know in my, the truism of the criminal defense bar is never put your client on the stand. Right. Look at the Murtaugh case. It did no good for his defense that Murtaugh testified. So I think it's unlikely, but we'll see. He's an extremely unreliable witness, and I worry that you get convicted here and you end up in a second perjury prosecution.
Moreover,
which New York would do with alacrity. Sorry, Elliot, go ahead.
No, I would just say, and as a defense attorney, you just have to get in your client's head that I know you might think, quote, you alone can fix it, as he said famously at the 2016 Republican National Convention. But there is a tremendous risk anytime a defendant takes the stand. And as a defense attorney, what I would say is you are about to appear in front of a jury that voted 87% against you.
And good cross-examination is a beautiful thing. It's exactly the thing that Trump can't handle, being forced to answer in the prosecutor's terms. We haven't talked about another figure in the court, and again, I'm hitting you with this. You may have no idea, but same judge who did the Trump Dominion case. What do we know about him from the Trump organization case in terms of the kind of trial judge he might be? Lets the parties go along, expresses his opinion or doesn't, that kind of thing. Any sense? I didn't follow it to that degree.
Tough.
Yeah.
He's
tough?
A
You
good,
have a sense of
tough. Yeah. Just from following the prior case and his reputation, and obviously with Trump kvetching about him on Truth Social. That caused me to ask and refresh on Judge Marchand. Tough, no nonsense. I think he's fair. He did not put up with any of Trump's BS. That is why Trump is so angry. So I don't think we're going to see a lot of tomfoolery. At a certain point, Trump's main tactic is delay, and it's been very successful for him, including he got another year here of Alvin Bragg figuring out what he wanted to do, right? Because he pushed this too far into Vance's. I'm looking for Judge Marchand not to give unlimited leash to Trump. But here's the thing I'm thinking about the most. Trump has called for death and destruction, warned of death and destruction. I think it was a hint to his followers. He's posed swinging a baseball bat at Alvin Bragg. What happens in court at the arraignment at 2:15 on Tuesday afternoon? Do the prosecutors say, Judge, we want a gag order here. Judge, we have concerns about what this defendant is saying? Judge Marchand is not one to take that kind of thing lightly. I don't think you're going to get anything at that first hearing other than you may see the issue ventilated and the seeds planted.
Yeah,
judges, that's what I'm watching.
Absolutely. Judges are so disinclined for First Amendment reasons to grant gag orders unless there has been clear and specific and actionable and a pattern of threats or misconduct in a way that, but I think Norm's exactly right here. I think that the parties air it, put it on the record, and we're going to return to it and see how long it is, if and whether the former president keeps going. But no,
Well, I mean, that's it exactly, because it's not just First Amendment of the speaker, but you're going to have a very strong argument. This is my campaign to the American people.
Right.
On the other hand, the only way this works is if at the end of the day, if he keeps upping the ante, the judge, and Trump keeps thumbing his nose, at some point he's going to say, next time it's civil contempt time, and bring your toothbrush. And then what happens? Does Trump then, stand down or not? This is part and parcel of a bigger problem. And this is so much of this is unprecedented. But you guys have been in high-profile trials. We start today a process. Well, actually, let me first ask you about the process. So the arraignment happens. Yes, he's fingerprinted, and the mugshot goes out to the world. Now begins pretrial litigation. What is the next thing that happens? A motion to dismiss, and when does it happen? Maybe just educate people a little about what the next few months of legal proceedings without Trump kind of look like.
A lot of this depends on what the actual indictment looks like. Now, one of a surrogate for the former president was on air today talking about the first thing you'll see is a motion to dismiss, trying to bootstrap a felony into a misdemeanor. Well, okay, well, wait until you see what the felony is and then make that determination. Now, broadly speaking, even without knowing, certainly it's not uncommon for a defendant to move to dismiss charges against him or her based on the law. And this goes beyond saying not guilty, right? Like, at the initial appearance, the defendant will, at the arraignment, will plead to the charges, and invariably here the president will say he's not guilty. Then after that, there's a period of saying, well, there are some legal infirmities in the charges that have been brought against me, and because they're legally flawed, they have to be thrown out. And I'd be stunned if this defendant, like many others, didn't try to do that on some of the reasons that sort of we've talked about.
My follow-up is just this. I mean, we'll figure out there will, of course, be a motion to dismiss. My sense is, but you've really gone to school on New York law, and really been, I must say, you and especially Ryan Goodman have been resources for this whole gang, and thank you. But my sense is it's been so critical in the Trump delay game, what sorts of motions are subject to appeal and what aren't. And my general sense of New York law is there ain't a lot. So the judge will do what he will with the motion to dismiss, and that will just roll into everything else that figures at the end of the day, rather than causing a whole halt of several months in the proceedings while it goes to the appellate court. Is that your understanding, or do you just not know one way or another?
That's fundamentally accurate, and I think you need to look also. We should not have this conversation, I was going to say, in the abstract. We should ask, because we have a good sense of what the Trump defenses are. His team has been ventilating them. One is that this case is somehow novel, that you never get a books and records case that is bootstrapped up into a felony because of campaign finance violations, if that theory of the case that has been advanced turns out to be the correct one. Well, as Ryan Goodman, myself, some of our colleagues look, and there are many of those cases, it turns out, in New York. There's the Richard Brega case, the Clarence Norman case, the John Doty case, Richard Luthman case, the George Manziar's case. These are all books and records cases where there were expenditures to benefit a campaign that were arguably outside the parameters, either the amounts or the disclosure rules. And that bumped up the false books and records into a felony. So they may try to say, well, it's novel. We've never seen a books and records case done for this, but it's just not true. Okay, now, of course, there's some very specific facts here. The hush money that was tried in the Edwards case, they May 2nd attempt to utilize Edwards. But let's remember, Edwards made it to the jury. There was no legal infirmity. There's no basis for a motion to dismiss. coming out of the Edwards case. Number
And
three,
sorry,
statute of
Norm, just to be clear, John Edwards, we're talking about here, the former
yes,
senator and presidential candidate. Yeah.
yes,
Clarify.
who paid hush money to his mistress. There were evidentiary infirmities, although there was also a hung jury. The prosecutor, who happened to be special counsel Jack Smith, could have, at that time, just regular old Jack Smith, could have retried that case. He chose not to. Because of evidentiary infirmities, including the fact that the payments continued to flow after the campaign. Here, the timing is right before the campaign. So, statute of limitations. Well, there's tolling doctrines that apply. They don't have a good statute of limitations case. Infirmities in the proof of intent. Well, there's each of those cases I just described was an intent to defraud the campaign finance authorities. That's adequate in New York. So these are not any more winning arguments than the usual arguments that Trump makes that have led him to his stunning series of court defeats, lately a number of sanctions against him and his lawyers. I'll do one last one. I could go on all day because, as you note, I've spent a lot of time studying this in recent months, and not just in recent months. I wrote a report saying these charges should be brought 2 years ago. Can you base a charge against a federal candidate on a state campaign finance violations? Can you use state campaign finance violations to bump up the misdemeanor books and records to a felony? I took a deep look at the law of preemption here. The usual rule that where the feds have said, hey, we're going to do campaign finance for presidential elections. This is full of, normally, you'd say, oh, the state can't rely on that. It turns out that campaign finance preemption law is full of holes. And circuit after circuit has allowed state authorities to move to bring cases based against federal actors where federal campaign finance law is implicated because state concerns predominate. So I think Bragg has that may be the toughest argument. I think Bragg has the better of that argument.
And I think that is the toughest one. The easiest is the statute of limitations one. The law is abundantly clear on this point, and this is sort of in lawyer speak. It's a bit of a gimme. I mean, stranger things have happened, and who knows? Maybe we're all wrong here, but the simple fact is a defendant who has been away from a jurisdiction for an extended period of time, the statute of limitations for crimes committed on that state soil will be told, like Norm said, or paused. Legal questions, like questions of does the law support this, can often be hard and very heady. This one's of all of them is probably the most straightforward, and they were making that argument on television all morning today.
I hadn't realized that. Yeah, that really is kind of fatuous. But it does point out, I mean, we have this very interesting dynamic, and it's a different kind of challenge for Bragg's folks. You have not just Trump, but you have all these surrogates out there making, brazen pronouncements without, like the rest of us, not having seen anything. That's going to continue, and we'll see. But how will the court deal with it? Is it going to try to gag Ron DeSantis, Mike Pence? And, normally this point comes and you've got the increased burden as a prosecutor, but you speak in court, very importantly. And also generally, society kind of takes a step back. We'll wait to see the evidence and then try to sort of pass judgment. But we're going to have maybe a year in which every little legal motion of the sort you gentlemen have just described, and just very briefly, after motions to dismiss will come, discovery, a lot of pretrial jockeying, where you're just going to get the public well poisoned, and basically I guess this is my question. There, by the rules of ethics, the prosecutors and Bragg himself can't really fight back. Are there going to be people taking their side or coordinating in any way? Or are they just going to have to take it on the chin until the time comes, if it comes, for an opening statement before 12 jurors?
I think the right thing is to take it on the chin and keep your mouth shut and sort of give the boring truism, the platitude that we speak through our
Yeah.
filings and our pleadings and don't, another one, but really an important one. And this is probably one that would come up on appeal rather than before trial, but they will raise it. This is a political prosecution. That is the argument
Right.
that those words, political prosecution. And there's just a broader point that I think it's in 45 states across the country, we elect prosecutors in partisan elections. To that extent, they're all political prosecutions in a way. What's important to note is that you got to get it past a grand jury that is not elected individuals, that is citizens, a majority of whom found that there was probable cause to believe that a crime had been committed. Regardless of the political party affiliation of the prosecutor bringing the case, it's got to hold up in court. And this one, at least as of right now, has withstood that first important apolitical legal hurdle. And people need to get that into their heads.
What's the point of talking feds if not to fill that void that is created by prosecutors' inability to talk?
Yeah. Good
Well,
luck to
let's
us,
go
but
light on
we're
the
talking about
rhetoric.
sniper attacks. Yeah, go
Let's,
ahead.
well, then you just, you
Yeah.
meet fire with fire, and that's why in those just security pieces, it's a 5-part series. That's why we've gone so deeply into the law, and we just need to keep hammering at it. The term peak television, it's peak
Yeah.
legal commentator television right now, and that's been very, very good to us, the three of us.
All right. Well, let's zero in on a little bit more. I mean, it's clear, I think, is it not, that at the end of the day, you're not going to have a complete socially accepted consensus, and some people will never accept whatever the outcome is. But do you see the prospects? Indictment. I mean, conviction or acquittal. Do you see it as likely that this trial can serve, and now we're going beyond the trial lawyers, the contours of the courtroom, but can serve the social function of a trial of actually, achieving some kind of judgment that, broadly speaking, society accepts and moves on?
I think so. I think the series of trials can do it. It won't be this one alone. But, we're going to be having this conversation in a few weeks or a few months. Elliot and I had a fun time on CNN predicting when this case would come. We're going to have the Georgia DA case. I think you're going to see at least one case from Jack Smith. You're very likely going to have judgments in the Eugene Carroll case. You're going to get the Fonnie Willis quasi-corporate death penalty case. That's a very important civil case. Those last two are civil. So I think that will have a collective effect that any one case probably can't have.
The unfortunate thing, it's almost a blessing and a curse for all sides here, is that the number of prosecutions Donald Trump faces are a bit of a Rorschach test in terms of, while the president is facing potential indictment in multiple sovereigns, federal, state, that can either mean, wow, this individual who has evaded scrutiny is finally facing accountability, A, or B, wow, all of these liberal prosecutors across America are colluding and engaging in a witch hunt against the former president. It literally is a Rorschach test.
Yeah, I think so. Look, and maybe there's an end for now, but it strikes me that what's coming is going to be just as roiled and politicized, but really straight up dry legal stuff. So there'll be all the more need for us. I hope we'll reconvene soon. Let me just, because we've all been thinking about and have different kind of vantage points, just end by asking if either of you, feel like there's some specific point that's been on your mind that you want to just, serve up for general cogitation to everyone, or you needn't if this is enough for one day post indictment, day one of the new era.
I think give it time and see what the law says, and then let's all as a nation reconvene, even recognizing that we have a general sense as to what's in there, but we are talking about that which we have not yet seen. And the other point I would make for everyone is you got to get something past a grand jury. After you get it past a grand jury, you got to get it past a real jury. Well, you got to get it past a judge for a year of motions, and then you got to get it past a real jury. These are all tests. And right now, a test has been passed by prosecutors. And regardless of whatever critics want to say, the simple fact is an apolitical, non-elected grand jury has found this individual or these individuals possibly to have committed crimes.
I think that,
Professor Ambassador Eisen, the last word to you.
I think that Alvin Bragg has surprised and I think pleased all of us who have we have a century of criminal law experience on this Zoom. It didn't leak that the indictment was coming Thursday. He didn't play games. It was very disruptive for me. I was in a car. I was told to pull over and find a Wi-Fi network and get on television. But that was very reassuring to me. And I think people should take reassurance pending. Elliot, of course, is quite right. We'll see what's in the charging papers. But if you look at the evidence, the evidence is strong here. If you look at the law, if you really go into it, there are strong precedents for doing this. Bragg has taken a year to think this through. That is a good, strong litigating office. It's one of the great DA offices in our country, in our history. And this is an important democracy matter. This false financial booking to cover up these alleged campaign finance payments might have changed the outcome of the 2016 election. That's more than you can say about the attempted coup of 2020. It should be prosecuted. So, it's a good day two of the new era for accountability in our democracy. We'll see what's in this indictment, and I predict future indictments to come in the other cases.
There you have it, everyone. Thank you so much, Norman Elliot. Hope to see you soon and regularly. Until then, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.